Now, to start out, I think it's good to recognize the USPTO is not the only governing body or body in general that creates ethical rules. We have rules even at a state level. When you become licensed within a state as an attorney, you have to abide by ethical considerations or state type rules as well. In addition to that, the federal government also says, well, any federal type licensed practitioner also has to abide by rules. So there's many levels of ethics that are involved with both attorneys and also practitioners. That includes, for example, patent agents. With that in mind, the Patent and Trademark Office also has their rules that they abide by to ensure that we, in fact, are being held to as high a standard as possible. In the textbook, you saw that there were 8 main sections that are associated with the USPTO's breakdown of ethical rules. The first one deals with client-practitioner relationships. Second is us acting as counselors. And when I say us, I mean both any type of practitioner, so be that attorneys or agents operating before the Patent and Trademark Office. Section 3 deals with being an advocate. Section 4 deals with transactions with persons other than clients. Section 5 are law firms and associations. Section 7, information about legal services. And number 8, or Section 8, maintaining the integrity of the profession. So when we look at all these sections, in short, they are trying to make sure that not only are our interactions with our client held to a high level, but our interactions with the general, with other attorneys, are being held to as high of an ethical standard as well. We'll cover just a few topics in relation to our discussion of ethics. First off, I think one of the first questions we can ask is, well, why ethics? This is a course on intellectual property, on having basic understanding of how to provide services to those that are coming to receive services from the clinic. And the answer to that is, much like anything in life, we need to have a common understanding of what is required of both you and of me. Because if we did not start with the base of ethics, we would be basing that off of assumptions. I assume that you will be honest with our clients. I assume that you will not misrepresent anything to our clients or even to me. So, but although that assumption I think is pretty basic and we would all abide by that inherently, nonetheless, it's good to know that we are held as practitioners to a much higher standard, that we require all individuals that operate before the Patent Office to abide by these rules. One thing to keep in mind is that you will be a licensed practitioner before the Patent and Trademark Office during your time with the clinic. So this is not just something theoretical that potentially you might have to actually operate by. No, this is actually very pragmatic. When you sign the line of saying that you are part of the clinic and that you submit your application, you are agreeing to abide by all the rules of ethics that the USPTO actually requires. So one, why ethics? Because it is required by law. Two, it promotes a higher level of living. And I think that's something that we can all strive to do no matter what level we are at. And 3, I think one other thing to keep in mind is it is not often with life we are looking at the minimum expenditure required in order to achieve the desired result. So, but in the case of ethics, I would say, no, do not necessarily skimp the corners in order to get to the intended result. Now, with the clinic, I expect you to be not just 99% honest, 110% honest with our clients. And it's the same with me. I entrust you with a lot of trust. I place in you a lot of trust. I am placing you before our clients with the assumption that you will act as essentially legal practitioners. For some of these clients, keep in mind that you may very well be their very first interaction with either an attorney or with some legal type practitioner. You may be their very first impression. So when we talk about ethics, yes, by all means, I expect you to act and dress the part of a legal practitioner, but even more than that, I expect you to go out of your way to be extra ethical, extra honest, extra forthcoming, and to make sure that all that is done in a manner that is in the best interest, obviously, of the client. Now, in the textbook, in section 1.12, you saw that there were a number of charts dealing with grievances. And in the textbook, I recognize that it is a black and white and gray type breakdown. But you see that, for example, in the breakdown of disciplinary decisions by practitioner type, you see that the vast majority are patent attorneys. That's the lightest color there. The darkest color are patent agents, and then the gray color are trademark attorneys. Now, first off, with respect to the patent attorneys, and you see there's a breakdown here of fiscal year 2012, 13, and 14. Now, obviously, the statistics have been updated since this time frame, but I included just a snapshot from a specific time frame to give us some discussion points here. First off, we noticed that the patent attorneys occupy the most number of grievances. Well, we would expect that. Not necessarily because they're less scrupulous, but rather because there's simply a much higher number of patent attorneys in relation to patent agents and trademark attorneys as well. So there are a greater number of practitioners that are patent attorneys, therefore we would inherently and statistically assume that there would be a greater number of potential grievances associated with them as well. You see that there are some fluctuations. You can see that in fiscal year 2012, the patent attorneys make up a little over 50% of all grievances. Compared to 2013, they're almost at 75%, and in fiscal year 14, they're roughly around the 40% mark. And you can see that the remainder of the grievances are split in some manner or separated between patent agents and trademark attorneys as well. As far as the breakdown of these types of disciplinary type actions, we see in fiscal year 2012, on the left-hand side, that there is a breakdown between a formal discipline versus a warning. So you can see that over 50% in 2012, that there was a formal discipline, in fact, was more prevalent than a warning. Whereas in fiscal year 13 and 14, warnings, in fact, were more prevalent than actual formal discipline. Now, I have a number of individuals that I know within the Office of Enrollment and Discipline at the USPTO, and they've indicated to me that their preference often is to give a warning. They want to be able to allow practitioners to really progress and continue forward. It's usually more in the extreme cases where if there is extreme egregious behavior on the part of the attorney or of the practitioner, that they very much feel compelled that they need to actually take some actual formal discipline. So that is not to say that if you do something wrong that you can probably just get away with it because the USPTO will not give a formal discipline. No, that is not my point. My point is that they are very often more interested in looking contextually at the bigger picture of what is going on here. Is this a repeat serial type offender? Was this just a minor type frustrated client who says, you know what, my attorney is not doing the best job that they should be doing? Or is this, for example, an egregious case where the attorney literally let some drop-dead dates pass? A drop-dead date would be a date by which the action actually dies. That's why they call them drop-dead dates. But these drop-dead dates are very important in the life cycle of intellectual property. So if you pass one of these very important dates up, that could very well be the basis for a potential formal discipline or a malpractice lawsuit. So you very much do not want to let these dates pass. We'll find out in other sections, for example, why it is that we have a docketing system. So with the clinic itself, we have a docket system. We use AppCall, and that tracks all of our deadlines to make sure that none of those malpractice type deadlines are passed up. You can see also the effects of what action was taken by the USPTO, whether, for example, the individual went through exclusion, suspension, or reprimand. So you can see that often there is almost a third split between each of those in some manner as well. So now I would like to focus on about 4 different related aspects that in particular come up repeatedly. Now these 4 aspects in fact correspond also with many of the top aspects that the USPTO has indicated are their big problem concerns. Namely that individuals that are practicing before the USPTO, where do they see the biggest problems arising? Now the first one would be neglect. Now neglect in general, you may say, well, if you have a docketing system, well, what are you really neglecting? Well, keep in mind that many practitioners in fact do not. And I would, in my mind, that alone is not a very smart business move. You need to have an official docketing system that is worth every single dollar. But some, in fact, for many years, especially in the case of solar type practitioners, may in fact have just been tracking those dates by an Excel document. And one of those very important dates may have been missed, which means that they may have failed to reply to an action from the patent office or from the trademark office. If that date is passed up, that could be the grounds for neglect, meaning that they failed to take action within a set time frame in order to ensure that something drastic did not occur. Second, there was neglect in the case of failure to communicate with a client. So your client may reach out to you, and there is a duty to reply to the client. So if the client is asking, hey, what is the status of my case? You have a duty to respond. Now within the clinic itself, it is expected that when a client emails the clinic, that whoever is over that client will respond within 24 hours. So that is my expectation up front. We are always striving that our clients hear back from us within 24 hours. Let me repeat that again, 24 hours. So what does that mean? It means that let's say that you have been assigned to a specific client. Well, you'll find out later on that one of the things we do is that we ensure that when you communicate with the client, it also goes through a peer review. So you can send a draft email to your mentor or to myself and say, hey, this is what I want to send on to the client. Any changes needed? And we may get some input, or we may say, yeah, that's great, go ahead and send it on. Now you may say, well, isn't that a little bit obnoxious? I'm old enough. I can go ahead and just write a nice professional email back to the client. And I would say, well, yes, you probably are old enough, and you probably are more than capable of responding in a very professional manner. This protocol is not necessarily to reflect a lack of trust in you. What it is just good general business sense. Most law firms, in fact, abide by this. If before you become a partner, as an associate with most law firms, anytime you correspond with clients, you often, in fact, will email at first to a partner to get their approval and input before emailing it on. You'd be surprised how often that even, I recall when I was an associate, there may be just 1 or 2 small changes that were made to the draft email, but nonetheless, they were important changes. So again, 24 hours is the goal that we are operating by which you should in fact be getting back to the client, which means that when that client email comes in, you should be immediately drafting a response email to be sent to myself or to your mentor, so that you are in a position to get that official email off to the client within 24 hours. Additionally, there is a duty to report office communication. So if the USPTO sends a notification out that says, hey, an office action has been received, or your matter has been allowed, it doesn't matter what the communication is, we are under a duty to disclose that to the client. Another form of neglect is failure or delay in filing a patent application. Now, in particular, in today's context, we are under a first to file system, which means that he or she that runs fastest to the patent office often now has the basis and grounds to get a patent. And so if you, by your own neglect, fail to get that patent application on file in a timely manner, then that may be some basis for the client coming back and saying, hey, it's because of your neglect that I am now stopped from being able to get patent rights. Additionally, failure to revive or assist in reviving abandoned applications. What does this mean? This means that if, let's say, you did not take action by a drop dead date and the matter goes abandoned. Now, the good news is there is sometimes a little recourse, a little safeguard, if you will. If it truly was unintentional, you can actually go in and for $1,002, do what's called revive the application. Now, I don't advise doing that as a general practice because when you let something go abandoned, it just looks bad. Secondly, you need to recognize that it is very expensive to revive. So it's not good practice to get into any habit whatsoever of actually letting things go abandoned and simply reviving. Now, also keep in mind that's just not good from a point of view of instilling confidence from the client, or trying to instill confidence in the client and what it is that you're doing. If you're letting things go abandoned and you're reviving, that's usually not good. Now, but what is worse is if you let something go abandoned and you failed to in fact revive. So if it was your mistake that something went abandoned and then you did not take action to revive, well, that's almost 2 strikes against you. And so you want to make sure that if you do make a mistake, that you're very forthright with the client. Say, you know what, it was my mistake, but I will cover the charge to revive. There are no ramifications as far as your patent continuing forward. Additionally, another area of neglect is failure to turn over files to a new representative. So in this case, let's assume that a new attorney was hired on. When a new attorney or a new practitioner is hired on, you are under a responsibility and obligation to transfer files over to the new attorney or practitioner. If you fail to do that, again, that could be a basis for neglect. The second area that the USPTO has focused on repeatedly is dishonesty, fraud, deceit, and misrepresentation. So essentially everything relating to some type of form of deceit or dishonesty. What this relates to, 2 global type groups. The first is concealing information from the client. So if you are taking active action to ensure that the client doesn't find out about specific items, such as the date of an office action, or the date by which something would abandoned, or the reason for abandoning. So let's say that you were lazy and you simply let a drop dead date pass you up. If you are not upfront with the client as to why it is it went abandoned, that could be grounds for essentially misrepresentation or deceit. You could also conceal information in the form of misrepresenting to clients a status of abandoned applications, or potentially if you were to indicate to the client that abandoned applications were still pending. So that would again be completely deceitful. If something really is abandoned and you're saying, oh no, it's still pending, it's okay, I've revived it. Well, no, you need to clearly indicate to them, yes, it went abandoned. I took action to revive it at my expense so that you don't obviously have to cover that. The second big section relating to dishonesty and fraud is making false or misleading statements, not necessarily to the client, but to the USPTO. And you would say, well, how would you ever do that? Well, keep in mind that you may be advocating on behalf of your client in a very strong manner before a patent judge or a trademark judge. They call them often administrative judges, and that's an administrative law judge. And so if you are strongly advocating on their behalf, well, that's good. We need strong advocates, but do not make any false statements. Do not indicate to the board or to any member of the USPTO that which is not truthful. And you may say, well, again, I would never intentionally make a misleading statement to the patent office, but let's assume that you have a patent that you, in fact, in order to get around some prior art, you misrepresent the date by which the patent was first filed. Now, that would be a very stupid thing to do because you can easily look that up. But my point is, let's say you do it because for the purposes of trying to get rid of this patent art or this prior art, you make that argument because you think it's a winning argument and allow you to go forward. Well, if it really is not true, if you are really putting forth false information such as the date on which the patent is actually filed, that's misrepresentation. So any form of misrepresentation, and I would indicate any form of stretching the truth. If you're stretching the truth in any manner before the patent office, that could be the grounds, obviously, for some type of conduct proceedings against you. Making false or misleading statements before the USPTO can also include a statement in relation to reviving an application. So generally speaking, when you revive an application, you check a box that says, I make an official declaration and statement that by filing this revival application, that the application was unintentionally abandoned. But let's say that a month or two prior to abandoning the application, there's an email string. And in that email string it says, oh yeah, the drop dead date is coming up. Oh, you know what? It's just not a good profitable type patent asset for us. Let's go ahead and abandon it. And then it goes abandoned, and then a week later the client comes to you and says, oh, you know what? I made a big mistake. We should not have abandoned that. It actually turns out it's the new big market and we need that patent protection. So the client says, make whatever statement you need to in order to revive it. Well, the only statement you can make is the statement that says this went unintentionally abandoned. So if you make that representation before the patent office, when it actually is not the case, in other words, you intentionally abandoned it, then that could be the grounds for also misrepresentation. Same thing to obtain an extension of time for reply or in response to an office enrollment and discipline inquiry if they're reaching out to you. If you misrepresent anything there, again, that could be grounds for dishonesty, fraud, deceit, or misrepresentation. There, in fact, is one other big ground, or I would say ramification of this, and that is namely in litigation. So let's assume your patent or trademark is in litigation, and my experience primarily is in patents, so I'll talk with respect to patents. So let's say that you make a false or misleading statement to the USPTO during the prosecution of the patent asset. Well, not only would you be potentially on shaky grounds as far as ethical conduct before the USPTO, but in addition to that, if a false or misleading statement was made before the patent office, that can also be grounds for invalidating the patent. So the ramification is not just with respect to your own conduct, it now is so far reaching that the patent office in fact will invalidate a patent asset if it is found that a false and or misleading statement was made. So going back to my example of your client says, hey, I don't care what statement you need to make, but we need to get that patent revived. Well, if later on in litigation an email surfaces, which let me assure you, during the discovery process, it often does surface, and in that email it says, hey, I don't care at what cost you need to, or make whatever statement you need so that we can go ahead and revive. That alone would be grounds for misconduct on the attorney's part. It would also be grounds to actually invalidate the patent as well. So in short, keep it honest. Be very forthright with the clients and with the USPTO. One of the other big areas that the USPTO indicates is with respect to fees or monies. So fee-related issues, and we would, and often this is not in fact even just with respect to the USPTO or IP type matters. One of the highest reasons why it is that individuals file for proceedings against an attorney or a practitioner is often money related. Issues over money, how the money is being handled, things of that nature. So fee-related issues may include repeated failure to reply to a fee-related missing parts. So if you were to file an application and you did so without paying fees, you get a notice from the patent office that says, hey, you forgot to pay your fees. you need to go ahead and pay your fees. If you repeatedly fail to actually reply to that notice, namely by filing and paying the fees, that could be some grounds for a fee-related type issue. Second, failure to return client's advance fees. So this is usually the client will put forth some type of a retainer into usually an attorney or a law firm's or a nonprofit's trust account. And that money usually is sitting there, and when the services are performed, the money can be taken from that trust account. But the issue often is, let's say that the firm is running short on money that month, and they said, oh, we'll just borrow some money from the trust account and then we'll put it back the next month. In other words, the money has not changed as far as the total amount in the trust account, but there was a little subtracted and that amount was put back the next month. Can you do that? And the answer is no. Once it's in the trust account, treat those as sacred funds. You cannot touch them unless the services have been rendered, in which case it can be in fact drawn from it. Improper commingling of clients' advanced legal fees with practitioners' funds. Again, that would go back to, you need to ensure that there is a trust account or some separate, for example, IOLTA account that is separate from the management fund of the firm itself. If checks were returned, or if there is some type of fee-related issue with respect to the fee being rejected, again, that would be some fee-related issue. Failure to disclose fee escrow or business relationship with invention development companies. So you need to be, again, forthright as far as fees associated with whatever type of transaction is going on. And last but not least, charging excessive interest on unbilled fees. So your client hasn't paid, and the question is, well, how much can you be charging them on interest? Well, all that they indicate is that you cannot charge excessive amounts on unbilled fees as well. The last section that I want to note is the unauthorized practice of law. And this is in fact a big one that comes up particular with respect to clinic students. Because some say, well, they're not legally authorized patent practitioners or trademark practitioners yet. And the answer to that is correct, but they are licensed according to the USPTO in a temporary fashion. What does this actually mean? It means that the unauthorized practice means that non-attorneys cannot practice before the office in trademark manners. In like manner, patent agents cannot even practice before the trademark office. You need to be a licensed attorney in order to practice as a trademark practitioner before the trademark office. The one exception is that for clinic students, they can operate before the office as trademark practitioners because they are being supervised by an actual licensed trademark practitioner. So you are directly tied, whether you are on the patent side, you are tied directly to me. And I give authorization. Everything that you do is going in essence under my umbrella. And like manner on the trademark side, everything that you do is also going under our trademark umbrella, supervisor's umbrella as well. But with respect to, let's assume that you, in acting as a practitioner associated with the clinic, often there are many in the public space that come ask questions. They want to get some advice on their patent or trademark related matter. It happens every single year. Just know that if it relates to something procedural, by all means you can probably answer it. You can look it up and say, hey, I can direct you to rule such and such. And as long as there's a basis for what it is that you're indicating, by all means, usually procedurally, you can give an answer. Where you cannot give an answer is where they are requesting a legal opinion. Now, if it is the public that is requesting a legal opinion, I cannot even give an answer. And the reason why is they are not our client. In order for me to give a legal opinion, they need to be our client, and we need to have an attorney-client relationship. So if somebody comes and says, hey, is what I have patentable? Can I even get a patent? Or is what I have can I go ahead and get trademark protection on this? What they're asking for is in fact a legal conclusion, a legal opinion. And what you can say is, you know what, I cannot speak directly to your particular matter. But what I can do is give you some guidance as to what it is, because again, you are not our client, but I can give you some guidance on other similar type items that have either been found patentable or not patentable, or that have been worthy or eligible for trademark protection or not. So keep that in mind, that if they are asking you to draw a legal opinion, you cannot. Now, that is also the case even with clients that you work with. And what I mean by that is if a client associated with the clinic is asking for a legal opinion, we will be giving them legal opinions. But the difference is, before you give it, you need to be running it by the supervisor. So either your mentor is signing off and looking at it and saying, yep, your legal conclusion is correct, go ahead and give it to the client, or the supervisor is looking at it and say, you know what, that is correct as well. So we want to make sure that any legal opinion or conclusion that is given to our clients is legally sound. In short, you need to be running it by those who are actually licensed. So last but not least, as far as further considerations with respect to ethics, when push comes to shove, the responsibility often is on you. I will not necessarily be looking over your shoulder and saying, hey, Mary, John, make sure you're doing X, Y, and Z. Make sure you're being honest here. No, you're an adult. I expect you to act not only like an adult, but I expect you to live up to the ethical responsibilities that you have agreed to abide by. And I think last but not least, I just really want to emphasize, I hope that the ethics is not just something that you do with respect to your time with the clinic. This should be a part of you. If you're going on and becoming an actual attorney, you'll be under several layers of ethical obligations and responsibilities.